My name is Jeff Morgan. I'm from Dallas, Texas. The Fifth Amendment to the United States Constitution says this: no person, and skipping down to the pertinent part, no person shall be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The 14th Amendment to the United States Constitution says this. Again, skipping down to the pertinent part, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The Texas Constitution, Article 1, Section 19 says this regarding the deprivation of life, liberty, and property, etc. by due course of law. No citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised except by the due course of the law of the land. And yet, as we skip to the Texas Family Code, we find that the due process protections given to us by the Fifth Amendment of the United States Constitution, the 14th Amendment of the United States Constitution, and also Section 19, Article 1 of the Texas United States Constitution are completely disregarded. These protections are completely disregarded. The Texas Family Code, Section 6.001 says this, and this is pertaining to the issue of the dissolution of marriage. Section 6 says, suit for the dissolution of marriage, Chapter A, the grounds for divorce and defenses. Now, number one, remember, there are no defenses in the suit for divorce. There are no defenses. That's the reality of it. So this whole thing about the grounds for divorce and defenses, I don't even know why the defenses are listed, because there are no defenses in the state of Texas to a suit for divorce against somebody. But Section 6.001 says this: insupportability. On the petition of either party to a marriage, the court may grant a divorce without regard to fault if the marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation. Only one person needs to make this allegation. If the other person disagrees and says, I do not believe that this marriage has become insupportable, I do not believe that there is sufficient discord or conflict of personalities that destroys the legitimate ends of the marital relationships and prevents any reasonable expectation of reconciliation, that person will automatically lose. The point is this: in either instance, the judge is making a ruling on a belief. He is stating that he believes the person who says that the marriage is irreconcilable. There is nothing judicial about this. The judge is taking a side in an opinion matter. Two people have various opinions, and the judge will always, again, without exception, always side with the person who believes that the marriage is insupportable. There is something strangely peculiar about this. In what other instance does the judge make a ruling based on an opinion? Except in marriage, the institution that we hold most sacred and most dear, that the judge can come in and say, well, I believe based on this spouse's beliefs that I will side with this person's beliefs against the other person's beliefs. And by the way, person B, the respondent, even if you have religious convictions or whatever against it, even if you both made vows before God, it does not make a difference. I am going to take the side of the other person. I am going to side with his opinion or her opinion. I am going to rule his opinion to be politically correct or her belief to be politically correct and grant the divorce. This is what is written in our Texas Family Code. There is nothing judicial about it. It is a subterfuge. It is a bunch of lies. It is a sham. It is a house of cards if we believe that the Texas family law is based on law. It is based on lawlessness. It is based on forcing a belief upon a person who does not agree with that belief and then calling in the judge to act as if somehow this person's belief is better than your belief. Even though you are fighting for your marriage and for your family, the judge always sides with the person who is fighting against the marriage and against the family. Now, after Section A, which is the grounds for divorce, we go to Section B, which is annulment, Section C, void marriage. Section D comes into jurisdiction. And what I found very interesting under this section, there is a Section 6.204 that the recognition of same-sex marriage. In this section, the civil union refers to any relationship status other than marriage that one is intended as an alternative to marriage or applies primarily to cohabiting partners, and 2, grants to the parties of the relationship legal protections, benefits, and responsibilities granted to the spouses of a marriage. So the first question I have is, what exactly are the protections of marriage? Marriage is a bond for those who are religious, formed before God, taken vows before God in the presence of witnesses. They covenant to be together for life. If it's outside of the church, it is a public commitment. It is an agreement. It is a covenant. The state, the judge, and the Texas Family Code completely disregards these things. So if the state and the Texas Family Code and the judge completely disregards these, what protections are there to marriage? Does marriage actually have any legal protections in the state of Texas? And I would answer no. There might be some minuscule protections on the fringe end of the border, but the marriage institution itself is not protected in the state of Texas, and this is in accordance with the Texas Family Code. It violates constitutional rights. It violates the 5th Amendment, the 14th Amendment, Article 1, Section 19 of the Texas Constitution, but we somehow think this is okay, that marriage is just a private matter between adults, and that one adult at will can dissolve the marriage, and that there would be no consequences to him or her. One person can, for any reason, for no reason, that person can make up a reason. It does not have to be true. This is the reality in Texas. You do not have to tell the truth in family court. You never get punished for perjury, and the benefits are that you may get a bigger settlement, because this is how unjust the law is in the state of Texas. And again, you don't have to worry about the respondent having any type of due process protections, because he or she does not have them. That is Texas in the Texas Family Code. Now, I have stated that you can make up a reason. You don't really have to have a reason. You can make up a reason that perjury is not even considered in Texas family courts as being something that is worthy of possibly even a reprimand. No, that does not happen. And in Section 6.402, regarding the pleadings, and this is under filing suit for the dissolution of a marriage, subchapter E, Section 6.402, the pleadings. A petition in a suit for dissolution of a marriage is sufficient without the necessity of specifying the underlying evidentiary facts if the petition alleges the grounds relied on substantially in the language of the statute. The Texas Family Code says this: on the petition of either party to a marriage, the court may grant a divorce without regard to fault if the marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation. Again, what this all means, nobody knows. But as long as you substantially use this language, you don't even have to present any facts. You can present your will. You can present your desire. You can say, well, you know what? I, as a woman, have now met a man who is richer, who's more handsome, who weighs less than my husband, who takes me out, who wines me, and who dines me, and I will file for divorce against my husband because for some reason I have now found this marriage to be insupportable. He is not as good as my new boyfriend, so this is obviously a very insupportable marriage. By the same token, a husband can say, I have been sleeping with my secretary, who is 15 years younger than my wife. She doesn't have any stretch marks, and she is very, very highly sexual, and she makes me feel good. She listens to me. She understands me. My wife is too distracted with the kids and with responsibilities of the house. And in comparison to my newfound love, this marriage has now become insupportable. And that's okay in the state of Texas. And again, I will say this. And you can disprove me if you wish to. 100% of the time, without exception, the state always, 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 without exception, sides with the person making the allegation, period. And it's so easy to prove otherwise. Disprove me if you would wish to. In the last 5 years, could you give me three cases in which the judge denied a divorce based on insupportability? Even if the respondent said, I don't agree, the judge will always, without exception, grant the divorce. Why is that? Where are the protections under the law in the Texas Family Code? They are non-existent. So when we talk about that same-sex marriage, they need to have all the protections of marriage. What are the protections of marriage? There are no protections of marriage in the state of Texas. Now, after going through these filing suit, we also have temporary orders, and that's right. Temporary orders can be granted for any reason, for no reason. I feel like I'm going to be hurt, or that he's not going to be happy, or that she might destroy the property or something. You know what? The judge will go ahead and give a temporary order. In fact, the judge routinely gives a temporary order for no basis. This is part of the whole process. You file for divorce, the judge issues temporary orders. They're actually written down, so they come out at the same time. Protective orders. Protective orders carry criminal consequences, and yet a judge, again, no reason, any reason whatsoever, made up reason, the judge can issue a protective order. On the motion of a party, for any reason, for no reason, a made-up reason, to a suit for the dissolution of marriage, the court may render a protective order provided by Subtitle B, Title 4. So, and by the way, if by chance you violate a protective order or a temporary order that you don't even know about, because you may not even know about it, the violation of a temporary restraining order, temporary injunction, or other temporary order, which would also include the temporary protective order, issued under the subchapter is punishable as contempt. But judge, I didn't do anything. It doesn't make a difference. It is still punishable by contempt. But judge, I didn't do anything. Doesn't make a difference. Because as judge, with my judicial nature, my judicial cap that I'm wearing, my black robe, I am going to issue these orders against you. But I didn't do anything. It does not make a difference in the Texas Family Code. Now, of course, we go from here, from that subchapter to subchapter G, which now we're going to be the humane part of the Texas Family Code. We're going to talk about alternative dispute resolutions. And the Texas Family Code lawyers, the attorneys, the divorce attorneys, they love this because this is a better way to do it. It's a kinder, gentler way to forcefully divorce one person from another. This is what we should be looking for. And there are some judges, and these are, I've got the guy's book, Christian judge, talking about alternative dispute resolution. He has not talked once about the fact that this is a forced divorce, that one person has had complete deprivation of rights. And in our society today, we try to tell the person who's being forcefully divorced, who wants to keep his family together or her family together, quit crying, just grow up, just learn to accept it. You're causing problems by this. That person is being deprived of rights in a way that most criminals' rights are protected, but if you're a respondent in a divorce, your rights are not protected, and yet the guilty gets better protection than the innocent. When I went through divorce, I said it would have been better had I been charged as a rapist or as a murderer, because at least then I would have been given, 1, the presumption of innocence, and 2, due process protections under law, neither of which I was afforded in the Texas Family Code. Now we also have a trial and appeal, and this is the part under subchapter H. They have trial and appeal in section 6.708. Costs, attorney's fees, and expenses. And I call this pay the attorneys. This is the pay the attorneys clause. And this is how you know that this whole Texas Family Code was likely written by attorneys for attorneys. In a suit for the dissolution of a marriage, even if I didn't want it, in that suit, the court, as it considers reasonable, may award costs to a party. So I've done nothing wrong. My wife sues me for divorce, and the judge may say, and by the way, you need to pay her costs. Now, this did not happen in my instance, but I know people that have had to pay over $200,000. Nobody agreed with the divorce, but the judge invoked the pay the attorneys clause to make sure that the attorneys got paid. After all, the attorneys are contributors to the judge's campaigns. That's a fact too. There's a lot of conflict of interest there, but that is a fact. So anyway, go on a little bit further. Section 6.711, and this is the part that I find very, very interesting. The findings of facts and the conclusions of law. And this is where we're going to put on we're going to sound really legal now. We're going to sound like this is a whole legitimate enterprise versus just a sham trial with a sham court, with basically designed to plunder people, to destroy families. Here's what it says: findings of facts and conclusions of laws. And I think this is important because usually there are very few findings of facts and there are really no conclusions of laws. A, in a suit for the dissolution of a marriage in which the court has rendered a judgment dividing the estate of the parties on request by a party, the court shall state in writing its findings of facts and conclusions of law, including the characterization and value of all assets, liabilities, claims, and offsets on which disputed evidence has been presented. A request for findings of fact and conclusions of law under this section must conform to the Texas rules of civil procedure. See, this is showing how legitimate this whole thing is. The fact of the matter is the action has no basis in law. An innocent person can go to court, be sued over nothing, no legal infraction, and the judge can order that that person's assets be taken from him. That judge can order that that person become a visitor in that child's life. That judge can order that if that person does not pay child support to the person who filed for divorce, maybe for any reason, maybe for no reason, maybe made up a reason, maybe because he or she wants to legitimize or hide their own evil actions under the idea that our marriage has become insupportability. It is a bunch of nonsense. It is a bunch of garbage. This is what our Texas Family Code says. The findings of fact and conclusions of law required by this section are in addition to any other findings or conclusions required or authorized by law. Once again, right now there are no findings of facts and no conclusions of laws needed, and nor are they given. Judges do this. Judges rule based on an opinion or a belief. And they always side with the person whose opinion or belief is that I need to destroy the family, I need to destroy my marital bonds, I have found happiness with somebody else, and therefore I claim that my marriage is insupportable by comparison. He doesn't love me the way my new boyfriend loves me, or she doesn't satisfy me sexually the way my new secretary satisfies me. This is a bunch of nonsense, it's garbage, and it needs to stop. This is a matter that should be brought to the attention of the highest levels of government. Our governor, Greg Abbott, used to be the Attorney General for the state of Texas. He is very well aware of this stuff. Every member of the House and every member of the Senate, they try to make it look like, well, this is just a private dispute. This goes against Texas public policy. It goes against the amendments to the United States Constitution, and it goes against the Texas Constitution. How much more serious does this need to be before our state will start to take action on this and quit destroying families at will and quit punishing the spouse who wants to keep the marriage intact or the children whose lives will be ruined by this action? Thank you.